Welcome to today's webinar. This is Mark Diamond from Contoral. Today we're going to talk about creating a California Consumer Privacy Act action plan. Many of us are just realizing that it feels like we had recently completed getting done with another major privacy initiative, the European GDPR. And now we just have a brand new one, the California Consumer Privacy Act. And there's a lot of discussion about this and a lot of impact with this law. Today we want to talk about something different. We want to talk about what do organizations specifically need to do to be able to comply with this act? What are some of the activities you need to put in place and what needs to happen? And to lead us through the discussion today, we have Tom Mighell. Tom is Vice President of Delivery Services for Contoral. He's an attorney. He's an expert on privacy. Certified information privacy professional, and also Greg Forrest. Greg is our CTO and a technologist and understands the technology around implementing privacy programs. Hello, Tom. Hello, Greg. Welcome to today's webinar.
Hello. Good morning. Good afternoon to everybody.
Hello. Glad to be here.
So, why don't we jump into it? And we're going to talk mainly about execution today, but it's probably helpful, Tom, for just to do a review of what is the California Consumer Privacy Act, what organizations need to do, what are the deadlines, et cetera, associated with it?
Sure. So the California Consumer Privacy Act was really it really came about in response to the Cambridge Analytica scandal and Facebook, all of that, and there were those in California who were increasingly concerned about the ability of organizations to keep information on us, and so there was actually a ballot initiative by this man and some others that gathered, I think, more than 500,000 signatures, way more than was necessary to put it on the ballot, to have a privacy initiative. The sponsor agreed to remove it from the ballot, but only if the legislature agreed to pass this legislation, which is why it passed in 2 days, after 2 days of debate, and I guess that's how really the sausage gets made. So I would expect, and we'll talk a little bit later about how we might see changes coming between now and the time that it becomes effective in January of 2020. The purpose of this webinar is really not to discuss everything that's in the law itself, but rather how to prepare for the law and its enactment. At its heart, though, and what I did want to talk about is this law is about the privacy rights of consumers and the consequences for companies that don't adequately protect those rights. So every consumer under the Act has the right to know the personal information that's collected about them, to know whether it's sold or disclosed and who it gets sold or disclosed to. They can access their personal information. They can request that their personal information be deleted or erased. They can opt out of the sale of their personal information to others, to third parties, and the last right is that they cannot be discriminated against for exercising any of these rights. They can't receive lesser services or be penalized or have to pay to not be discriminated against or to not to have any of these rights taken away. The penalties here look deceptively small. It's not very large numbers here. The California Attorney General can bring an action by which they can recover damages between $2,500 and $7,500 for unintentional or intentional violations, but that is per consumer. That's not just for one violation. So if you have a lot of consumers whose rights were violated, this could add up to a lot. Similarly, for data breaches, a consumer has a civil right to come and get about $100 to $750 per incident. Again, not tremendously large. If the data breach tended to cause more damage, they could get more money. So this is not a small consequential act. We think that the dollar amount and the penalties could be big, especially for organizations that deal with a lot of personal information.
And I guess, Tom, one of the questions is, because consumers have the right to take their own actions, it's unlike, for example, some other areas, other privacy laws where they have to depend on a regulator to take a lot of this. We expect a lot of litigation around this, I would assume.
No, that's right. Is that here the consumer has the right to bring their own lawsuit, which I would expect would lead to a lot of potential class actions, a lot of other things coming on. It's not just going to be the Attorney General who brings these. It will be consumers as well.
All right. And so who is it? I mean, is it everybody in California? Is it businesses? Is it state and local? I mean, who government entities? Who's covered under this law?
So here is the basic coverage on this particular slide. If you are a business that collects or sells personal information from or about California consumers, pretty broad. Let's go into that a little bit deeper. A business needs to have one of the following three. You either must have annual gross revenues in excess of $25 million. You must either annually buy, receive, or share more than 50,000 or more consumers' personal data, or 50% or more of your income needs to come from selling personal information. If you can answer yes to one of those questions, then you are probably a business that comes under the law. Collecting or selling can mean a lot of different things. You can buy, you can rent, you can gather it, you can even receive personal information, and that counts as collecting. Selling, also the definition is likewise broad. You can just make it available, and it comes under the definition of selling in the Consumer Privacy Act. So if you deal with personal information at all and you are a business, likewise you may be covered. Whether it's personal information or not, we'll talk a little bit more about the definition of personal information under the Act, but it is in general information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked with a particular consumer or a household. We'll talk about that a little bit more later. And then a California consumer is defined by the law as any natural person who is a California resident. So that means that every individual in California who is there for anything other than a temporary or what they call transitory purpose, or every person who is domiciled, who resides in California, but who is outside the state for a temporary or transitory purpose, they all qualify as consumers under the law. And I think, frankly, that means that if you do business in California, or you do business with people who are residents of California, that even if they travel outside the state, you may be required to comply with this law.
Pretty broad in terms of its impact out there. And it covers obviously both residents, but also employees too, correct?
That's right. Natural person means everyone. So even though it's called consumer, for purposes of the definition, it's going to include not only the information that you collect on your customers, but also on those you collect on your employees.
Now, we've heard, Tom, that the law that we have today is not the final law. What's going on here?
So there's a lot of time before implementation. It's not quite as long as we had before implementation of GDPR. So there's a little bit of a condensed timeline. It takes effect on January 1st of 2020. During that time, the Attorney General of California is going to issue regulations. He's going to clarify the law. He's going to make modifications to existing law. And we expect to see those types of things happening. I think we're already seeing some legislation change in response to the original law, and we'll probably get a lot more guidance on how to comply with the law. What's, I think, almost certain not to change are the rights that the law is granting to consumers. I would expect those rights to stay the same. I don't think that that's going to change any. I think it will be interesting to see whether the definition of personal information changes. Already there is a lot of lobbying going on to try to limit or narrow what constitutes personal information. For example, marketing or advertising technology companies are asking that cookies and IP addresses not be considered personal information. I would not expect that to change, but I would definitely pay attention to this between now and January of 2020. And then finally, California, this was not their first privacy law. They had a bunch of other privacy laws on the books when this one was passed. And some of those are probably now in conflict with the new law, or at least make enforcement confusing. Which law do you follow in order to comply? So I would expect either some repeal of the older laws or some modification or integration that they would come into better alignment with the California Consumer Privacy Act.
Now, some may be saying, hey, why should I go ahead now and start working on implementing compliance for this law when it's not settled yet? Wouldn't it be smarter sometimes just to wait till the thing is fully baked and then we can go ahead and start implementing it?
I think no. I think that, you know, the action plan that we're going to talk about, I think is going to cover the big parts of the law, no matter what changes moving forward. I think that getting started on it now is by far the better practice, because there is so much of this that is similar to the GDPR, and we already know what's required under GDPR, that the changes that come based on, you know, between now and January of 2020 are not likely to really substantially or materially change the action plan that any company is going to need to start following.
All right, now some may be saying, listen, I don't have a lot of consumer information. I'm not located in California. Should I even care about this? Is this just really about those who have California consumers' data?
So obviously, if you don't qualify from that slide before, if you're not a business that collects personal information on California consumers, if you can legitimately say that you don't qualify, then at least today, you probably don't have a lot to worry about. But let's be honest here. California legislation tends to go where other states are hesitant to tread, and they sometimes go farther out than most states are willing to go. They've been very proactive in passing legislation that would really not go over so well in other parts of the country. But I think privacy is a different animal. It's an increasingly important issue for everyone. Data breaches are becoming more common. The threat of hacking is a worldwide phenomenon now. So it's something I think we're going to see a lot more of, which is, I guess to say, let's not be surprised if this is just the first one, that other states begin to pass this law. And that's, I think, part of the reason why we think it's a good idea to be prepared, especially if you do business in California, but even if you don't.
So a lot of organizations have implemented the European Union General Data Protection Requirements guideline rules out there. If they've done GDPR, do you need to do anything for the California Consumer Privacy Act? Where's the overlap? Are they the same, or are they different?
Yeah, we've talked to a lot of people who say, we're ready, or at least we're trying to get ready for GDPR. Can't we just use the work we're doing to comply with the California? We think the answer is yes and no. There are definitely differences in the California law that you need to consider, and we've tried to put them here, kind of the differences between the two. I'll cover them very briefly. The scope of California privacy tends to focus primarily on the rights of consumers and disclosure of that information and transparency of organizations. While GDPR is much more omnibus, it covers a lot more. It's a lot more prescriptive. There's a lot more about technology and security in there. The California Consumer Privacy Act is much less prescriptive. On personal information, the definitions are somewhat close. I would argue that California is a little broader because it includes households. It also includes devices. So I would say broader than the European Union. The rights under California privacy are broader to access and deletion of information. Like I said, security is not included in the California Act, where GDPR really has procedures around how to protect the information and how to make sure that an organization is implementing privacy by design rather than reacting to it. Disclosures, there's specific requirements for disclosure, how to do the information under California, where GDPR is more principles-based and less prescriptive. With data sharing, it's interesting. There are really restrictive data sharing requirements from the GDPR, especially with countries outside the EU. No such restriction on the California law, but that data sharing requirements between agencies and between organizations that share personal information actually tend to be a little bit more restrictive. The last four on this list are actually areas that are not included in California privacy that we think are great ideas for organizations to undertake in terms of protecting their customer and employee information. Like I said, privacy by design or default is a great goal to be working toward, making sure that you're addressing privacy at the front end and not on the back end and retrofitting everything. Conducting data protection impact assessments to make sure that whatever business process or technology you implement is adequately protecting information. Breach notification. California has a data breach law already, and that may need to be brought into alignment with the California privacy law, but it's not included the same way that GDPR is. And then finally, there are no requirements for a data protection officer or office or any type of organizational structure. That's not to say that we might not see some of these things come up as part of the guidance coming in, but as the law is written today, those aren't the requirements. So there's a little bit more in GDPR for some things, and there's a little bit more in California privacy. So it's not a great one-to-one. So you can't say that if you're in compliance with GDPR, you're automatically in compliance with California.
But there is some stuff you can leverage, obviously.
That is right, exactly.
All right, so Tom, let's switch gears a little. We talked a little bit about what the law is. Perhaps more important, what do you need to do? What do organizations need to do to be compliant with this? And what are the steps they need to take?
So this is a layout of the steps that we think companies should take to be fully ready for California privacy and beyond. Some might argue more than ready. We'll discuss these steps, I think, in more detail in some of the slides to come. But here's how they start out with a realistic assessment of your current privacy capabilities. Where are you now? Where do you need to be? Then you take inventory of the personal information that you've got and how you currently manage it. You develop or update policies, privacy notices, and develop procedures to actually manage your privacy-related information. The next step is to look, or series of steps really, is to look at the way your information is currently protected, enhance it, or find new technology, and make sure that it's organized so that you can easily find it if a consumer has a request to see it or delete it or do something with it. Of course, you're going to want to include some level of privacy training for those who handle personal information. And there also needs to be a way of disposing of that personal information when it's no longer needed. We think that these steps taken together, they make you, I think, compliant with California privacy and then some. They really enhance an information governance program.
Okay, so let's jump to the first step. And the first one you have here is really a maturity assessment and roadmap out there and assessing the current state. Yeah, now, some may ask the question saying, with so much stuff to do, why are we sort of looking at how we are today? Don't we want to jump in and start fixing things so we're compliant?
Well, there is some merit to saying, let's take a focus on the things that we need to fix. A lot of organizations, though, really need to take a look at where you are to know where you're going, because sometimes when you rush to fix things, kind of in a fire drill type approach, you may not do them in the right order. You may realize that there's some other things that really should have been fixed first. You've got to take a step back and deal with it. It really sometimes makes sense to sit down and say, where are we and where do we need to be? And these are the 4 steps that we usually see as part of a privacy maturity assessment. It's a pretty, I would call, a straightforward look at how you currently manage personal information in your organization. That first step, the discover step, is sort of understanding what kinds of personal information do you store, where do you store it, how do you classify it, what reasons do you have it, just learning where in general, at a high level, where is it, what do you do with it, how do you need to use it. The assessment then under the manage step really looks at what are your current policies and procedures for managing that information? How long do you keep it? How do you respect an individual's rights regarding their information? How do you manage the risk of keeping that information? The next step of the assessment is understanding how you as an organization protect personal information from whether you integrate privacy into new technologies to whether or how you protect against or respond to a data breach. Finally, the last part is kind of an audit and monitoring function that is assessed. How do you communicate your privacy program? How do you respond to a data breach to your consumers, to your clients, to the regulators? How do you measure compliance with privacy policies? I guess, do you measure compliance with your privacy policies? This audit and monitoring function is probably one of the most overlooked when dealing with privacy programs, and we think it's really important for the assessment process.
Well, and I guess it's also important too, because compliance doesn't come from a policy, it comes from how well you're actually executing the policy, and we believe the regulators will really look askew at organizations that never really tested their policy, and a good audit program will make sure that, hey, this is working, and if it's not, be able to remediate that. I mean, that's a very important part of that.
Agreed. So once you determine where you are and the maturity level for how your organization manages it, then we think you can start to develop first a remediation plan. How do we fix all of this? And then create a roadmap that prioritizes the things that you need to do first to comply with California privacy. And then there are other things. Say, you know what, this may not be required for California privacy. Let's put it on our roadmap, but maybe we'll get to it in a couple of years, because you may not be able to do everything at once. You need to really take a hard look at, here are all the things we need to do. Let's prioritize it and come to make some smart decisions about what our roadmap looks like. Now, the next step that we recommend, and one that's going to really come into play a great deal with California privacy, is the personal data inventory. This is essentially understanding where all of that personal data is located, how it's managed there. We think the best way to start a personal data inventory is really not to start thinking of the repositories where personal data might be stored, but rather, what are the processes in your company that result in the collection of personal information? What are the things that you do? It might be onboarding information for new employees. It might be website registrations from potential customers. Most of these processes are going to lie around your customer-facing operations, and then some of them are going to lie around human resources. Once you've identified these processes, you'll need to ask more questions to complete your inventory. What is that exact information that's collected? What's the personal information elements that are collected? Where is it stored? And this might be more than one repository, especially if the information moves from one place to another as part of the way that you use it, where it flows and how it flows, and whether it flows inside or outside the organization. Who has access to the information in all these locations? Who gets it? Who has control over it? And to whom do you transfer that outside the organization? Finally, how long do you need to keep that personal information for your business to operate? We'll discuss that more a little bit later. You might find that there are patterns that are unique to your business that might enable you to use technology to find that information, similar to tools that can find social security numbers or credit card numbers. And while completing that personal data inventory is important, you're really not done at that point. You're going to want to take a look at all the processes and repositories that store or deal with personal data, perform that gap analysis, figure out what's missing, what needs to be remediated, and then actually perform that remediation of the capabilities if that's required. You're, I think, of course, going to want to update your privacy policies, your privacy and consent notices. If you don't have them, you're going to want to create them. Under this rule, you're going to need to be able to communicate individual rights to the consumers and the people whose information you hold. You may also want to look at the procedures around managing personal information. Do you have data security classification standards? Do you have a data breach response plan? Are you conducting privacy impact assessments? While these are not necessarily required by California privacy, all of these are what we consider to be the baseline of having a mature privacy program. One thing that California privacy does require is that you place a prominent link or button on your website that allows people to opt out of selling your information. Just with one click. That's That's actually one thing that is specifically required by the law. And I think that will likewise and include developing procedures for processing these opt-out requests. So that's some of the things you need to think about. It's not just a matter of developing the policy, it's actually developing the procedures on how to comply with the Privacy Act and with the policies themselves. Now, because the California Consumer Privacy Act gives consumers the rights to access or have their personal information deleted, it's going to be critical for organizations to have a process in place for responding to those requests. The CCPA requires that you provide at least 2 means of making that request. Probably the most common are going to be toll-free number, maybe a link on your website will probably be the most common that you think about. But you can, I mean, no matter what you choose, you can rest assured that consumers are going to try to contact you everywhere to request access to their information through social media channels, via a help desk if you have tech support, by calling any numbers, any phone numbers that you have on your website, or even just sending emails to people in the company. Even if the answer that you give them is, please submit your request through the proper channels, and here are the proper channels, you're going to need to have a process for responding to these requests. And then once you have that proper request, once you get it, you're going to need to be able to verify its authenticity. Did it come from the owner of that personal information? Or did it come from someone who's a hacker, who's trying to commit some identity theft? Having an authentication process is going to be really important. And I think finally, to respond to the request, you're going to need to have to find a way to look for, to review, to produce that information, all within a 45-day time period. That's what the law gives you. There are some exceptions which can increase that amount of time, but 45 days is the standard amount of time to respond to a personal information access request. We'll be talking about this, I think, more in a few minutes, but this is where having a good data placement strategy, having a good taxonomy will make finding and producing that personal information a whole lot more efficient. And I think that there are a number of technical steps that we think organizations need to keep in mind, and I think that's where Greg's going to want to talk and bring up what are the things that need to come in from the technical side.
Thanks, Tom. Yeah.
Okay,
so
Greg.
When we're looking.
Tell us a little bit about privacy and security enhancements. I mean, Tom talked about the policies, he talked about some of the processes, but at some point, people are going to have documents and data that contains privacy and other sensitive information that needs to be secured. I mean, what do organizations need to do?
Yeah, so I think if we look at this, without taking too much detail, the first thing we see is that, well, all my information is in my customer-facing system, or I do my sales work, or where I do my marketing activities, so that's all I really need to protect. But that's not really the case. Unfortunately, in today's distributed world, people are always taking extracts and reports and pieces of those systems and moving them to devices, whether that be places where they store files, whether that be phones, whether that be iPads, maybe your people in the field have a bunch of personal information on their laptop. So when we look at privacy and security, we have to go outside of just the core systems that originally held the information to all the other places it might live. And so what we start looking at is, first off, what can move between certain types of repositories? How do we prevent people from moving things off of their laptop that they're using at work onto some other device that we're not controlling? Well, there are ways to do that. Virtual desktops, systems like cloud access security brokers that sit on the edge of your firewall and kind of make sure that certain files don't move where they're not supposed to. You need to look at access. Obviously, if your access controls on your core system aren't very good and you allow a whole bunch of people to have the ability to run a report that then takes a bunch of privacy information out, that can be an issue. You need to have the business involved in making sure that the right people have access. That can't just be an IT activity. Maybe some of the best way to do this is to make sure that the information that is behind your firewall is secure and encrypted, so that if someone does breach or break in, they can't get to information on an individual laptop. That's what we mean by endpoint encryption, or for instance on a phone or an iPad. And then there's information rights management, and many companies are now putting that capability into their systems such that it might be that someone could share a file, but it couldn't be printed, it couldn't be transferred to someone else, it couldn't be stored someplace it wasn't supposed to be. So those capabilities now exist. And finally, when you do have systems where you know that information should not be stored because there's too broad a permission set, well, you need to be able to scan those repositories and make sure that they don't have privacy information in places where too many people have access. And these are tools, data loss prevention, and file information. The next slide kind of goes into the tools themselves, but these are the functions that you're looking for. So the very first thing that Tom talked about quite a bit was access. I mean, probably the biggest change in the law is that within 45 days, any consumer is going to expect you to be able to say, here's all the information we have about you. Well, that means you need to be able to do search and e-discovery. And if a lot of the information that we're talking about is stored in places that don't have built-in search and discovery tools, that's going to make it very difficult. So in some cases, it's going to be adding a tool to do that search. In some cases, it's going to be moving away from repositories that don't have those native capabilities. I talked a little about information rights management. Certainly, Microsoft in their cloud environment for desktop, Office 365, has put a lot of time and energy into making sure that there is information rights management capabilities so that individual files can be tagged in a way that will prevent them from moving outside of your environment or from being put on devices that aren't secure. Virtual desktops. The nice thing about that is no information actually lives on the laptop. It actually lives up in the cloud somewhere and is accessed by the laptop over the internet. Or if they do have some of that information on them, they tend to be protected in a way that no one can get to them. Same with mobile devices. There is great technology that allows you to keep people from getting to information stored on a device, from a simple password on your device that everyone has today to actually being able to remotely say, uh-oh, this device has disappeared. We're going to delete all the email off it the first time it comes online. You know, cloud access security brokers. The nice thing about these is you might have 10 or 15 different ways of sharing files inside your organization. These tools can scan them all and make sure that things don't go where they need to. And finally, data loss prevention, we talked about that. What that really means is that I have the ability to scan and find things. Now, I've got a lot of technologies here. I don't just go out and buy technologies, though. What I look at is my requirements. Where are my biggest risks? Where am I going to get in the most trouble? What can I fix quickly? And what can I enhance instead of replace? In a lot of cases, this technology may already be available to you. You may already have a license for it, but it may not be fully implemented, or you may not be doing the proper monitoring of the information to correct problems as they occur. So again, technology requirements, it's not about going out and buying the latest new cool toy. It's instead making sure that you get the technology that you need to meet the exact pieces of the act that you're not currently compliant with. So let's talk a little bit about taxonomy. So what is taxonomy? Taxonomy is basically information that gets attached to a file and travels with it that allows that file to be classified in some way or another. That might be as simple as a privacy and a security schema such that when things have privacy information in them, they're considered private, and all the different tools we just talked about react differently when that metadata is there. The idea here is not to have your employees have to mark every single file as having privacy information, but instead to make sure that the places that you've designated for them to store that information actually pick up that metadata and automatically associate it with the file. Now, this is going to be based on the repository, and many repositories, file shares being the best example, don't have this capability built into them natively. So a lot of people, again, are moving to more modern document management systems, cloud-based systems that do have this particular capability. And finally, taxonomy is about training people such that if they are in an environment that where the tags aren't coming in, or where they have the capability to tag but they're not doing it. You need to educate the employees, because taxonomies only work if employees use them properly and place their information in the right place. So when we talk about metadata inheritance, what this really means is I have one place where certain kind of information goes, so that if I have medical records that I know contain PHI, I want to make sure that they go into a folder or a library or a container or a section of a particular storage area that is marked as medical records, and therefore will inherit that confidential security classification and that PHI privacy classification, as well as a retention, so that I can follow my own rules for how long I'm going to keep things, and I can also make sure that it's classified appropriately without the employee having to worry about it. They just know they have a medical record, and if they store it where the medical records belong, that metadata is inherited. So, how do I go about starting with privacy and security controls? Well, first you want to lock down your repositories that have the most and largest amount of privacy information. That's a no-brainer, and a lot of those will already have pretty good controls. If you are going to look at new repositories, you want to make sure they have built-in controls. There are lots of file sharing tools out there that make your employees collaborative both internally and with the outside world, but you want to make sure that the ones that you pick are controlled by you and have the right controls so that the employees can do the right thing. Look at suites of products that have a set of controls that go across them. I'm going to use Microsoft as an example. This is just one set, but they have controls for their file sharing application, for their email application, for their document management suite, SharePoint, for their instant messaging application, and for their social media. And if once you've tagged a file anywhere inside that suite of products, all of the suite of products actually follow those controls. So that's an important thing. If you can get a bunch of different parts of your business all handled with a single classification scheme, you're way ahead of the game. You know, frankly, we just talked about file sharing. Most companies have a supported file sharing environment from IT and 6 different other ones that the individual business units are using because they work with some vendor or they like some version. That's not a real good idea. You want to kind of reduce and consolidate the number of different ways that files can be shared both internally and with the outside world. You want to do pilots. Don't try to do a huge big bang. Try small pilot sets against data to make sure the products work before deciding to put them across the entire enterprise. You know, a lot of times people write policies that are very strict, but the capabilities of the technology actually don't fit what the policy says. You want to make sure that your policies and your capabilities match each other. And then finally, and I know Tom's going to talk quite a bit more about this, you really need to communicate and train employees on what you've done. I've worked in the industry for a really long time, and I will say that security and privacy-oriented people like to keep things secure and private. So in a lot of cases, they don't necessarily tell end employees what they're doing behind the scenes. That can work against you. You really need to let your employees know what controls you've placed, why they're being placed, and train them on how to use them properly. And then the final piece for technology. There is a lot of great technology employed in many companies, particularly in the data loss prevention area, and even in some of the firewall and breach response activities, where there's a tool out there and it is doing monitoring, but there's nobody whose job it is to go look at those reports on a regular basis, or to correct things when they occur, or your level of breach response is only if somebody's trying to take thousands of files, not necessarily hundreds or tens. So at a lot of point, you need to do some regular monitoring and audit. And that basically means not just do I use the tools, but I have policies that indicate how I'm going to use the tools. I have the right tools employed, and then I check and make sure that the tools are working properly, that I've got proper metrics, so that I can basically say, look, we've done everything as a company that we can do, and yes, this information still got lost, but it wasn't because we weren't following our own procedures. Thanks, Tom. We'll talk to us a little bit about communications and training.
Yes, so I think next in the action plan, you figured out where you're going, you've developed your policies and procedures, you've either purchased or enhanced your security controls, you've got your information organized. The next part really is training people on how to use it, but it's not really just on how to use it, but it's about privacy itself. And training is not specifically required by the California Consumer Privacy Act, but we'd argue that you actually really should or must train your employees in order to ensure compliance. At a minimum, training your employees who either, one, manage personal information on behalf of the company, or two, who might be responding to consumer access requests. They need to know the concepts around what you're trying to do so that they can comply with the law. Not only does training help you to comply with the act, but in the event of a data breach, in the event of some other violation, you can point to that training as proof of good faith, that you had good faith efforts to comply with the law. And on the other hand, a lack of training is going to show exactly the opposite. A lack of good faith, it's going to point towards non-compliance. So having training on introducing these types of things, the importance of privacy concepts are really important, not just for those people we're talking about, but also for all of your employees. Why is privacy important? Why do we protect personal information? How should we respond if there's a breach or some other disclosure of personal information? Helping your employees to understand the types of information that need to be protected, what you as an organization are doing to protect it, and how they can and really should be helping and what their responsibilities are, also greatly help with your compliance, whether it's CCPA or any other privacy regulation. It's really important to have privacy one way or the other. Now, what's the last part? I think the last part of an action plan is actually dealing with the rest of the data that's out there. Greg, do you want to talk about legacy information?
Sure. I think we're really good, particularly in the IT space, about doing go-forward plans that do something new well and make sure that everything from now on is going to be protected properly. But in most companies, there's a lot of legacy privacy information left lying around. And the most likely place that it's left lying around is on individual devices and on file shares, to be honest. And so the issue is, what do? Do we leave that information where it is? And if we leave it on those laptops and we leave it on the file shares, what does that mean for us? Well, it's easy because I don't have to do anything, but the bad side of this is it's very difficult at that point to classify the information, to do information rights management, to control the movement of information, and most importantly, e-discovery against individual users' devices and file shares that don't have pre-built indexes in them may not be fast enough for you to keep up with the demand of all the access requests that you're getting. So this probably isn't the best way to go about it. Probably you need to move information off of your end user devices and your file shares as much as possible to repositories that are much better suited for that information. And so what that really means is, first off, if you've got a whole lot of information on those devices that you're not supposed to be keeping according to your records retention schedule and your records management policies, you've got the ability to clean that information up. Whether that be obsolete information or whether that be information whose retention time has passed. Reducing information makes it super easy to move to another repository. It also makes your discovery requests and your ability to search go much faster because you don't need as much horsepower if there's not as much data out there. So, basically the idea behind this is to reduce the overall volume of data and then to move the data into repositories where it's well managed, where it's controlled, where there's a good taxonomy, and where you can enforce information rights management. Now, the downside of this is it's a project. It's going to take time to go ahead and do this. And to be honest, even with cloud storage, it's often more expensive to store things in a controlled fashion than it is on just raw file space that you already own. That said, over time, the costs of finding that information, managing that information, protecting that information, and deleting that information will actually outweigh the cost of moving it to a more controlled environment.
So the final component of what we consider to be a mature privacy program is some type of privacy organization. Again, this is not a requirement of the California Consumer Privacy Act, but frankly, if you're developing privacy policies and procedures for your organization, you really are going to need someone to administer them, someone to promote them and enforce them. Otherwise, it's just like we discussed on other webinars, having an information governance or records management program, but no one to actually, enforce the policies. No one is going to feel obligated to follow the rules, or maybe even know how to follow the rules. This diagram that you see here sort of represents one version of a privacy organization. Yours might need to look different due to resources, due to your organizational structure. If you have a business in the European Union, you may already have a structure built around a data protection officer. And usually we see someone in that chief role. A chief privacy officer is what we would usually call it in the United States. In the European Union and the GDPR, they're calling it a data protection officer. This person would, in this organization anyway, report to a matrix steering committee, a cross-functional steering committee made up of legal, IT, records management, information security, the business. It's not just a group to oversee privacy, but a group to oversee all aspects of your information governance organization, which would include records management, litigation readiness, information security, and other areas. Because that chief privacy officer can't always do it alone, depending on the size and breadth of the personal information that you collect, you may also want to identify support for them. That might be a compliance lead for the department or function, someone who has subject matter expertise both in the area and in the information that needs to be protected, so that they can one, not only instruct people on how to do things, but two, to measure and monitor compliance with your privacy policies as they roll out. It may be instead that you have someone on a slightly lower level, that you might identify what we would call a privacy champion, someone in each department and function who can answer questions about the privacy policy or the program elements. Maybe they could do training if necessary, and then they would be more of an assistant role to the chief privacy officer or whoever the head of your privacy program is to help ensure compliance in that area. It's really important to have not only someone in charge, but people down at the business level who can help with just the day-to-day activities to make sure that things are enforced or that questions can be answered when they come up. So I think of all the steps in the action plan, and we showed the action plan at the beginning, which are the ones that are actually required by California Consumer Privacy Act? If you've read the CCPA, you will see that it largely leaves out how you comply with the law. It leaves that up to you, to those of us, to figure out how to comply with it, only that you respect the privacy rights of consumers. So if we're going by a strict reading of the California Consumer Privacy Act, we would say that you absolutely need to have what's in red here. You absolutely need a personal data inventory. You need to either update or create privacy policies and notices, and have solid privacy and security controls in place over all your personal information. At a minimum, you've got to have that. And I guess also included in that privacy controls is a way to respond to personal access requests. We would argue, however, that to get to that point, you're going to need the steps in the middle. What's yellow there? The baseline. You will need to either enhance or purchase that technology in order to protect the personal information, and you're going to need to organize it in such a way that it makes it easier and more efficient for you to find and produce it if there is a request for personal information. Now, while the steps that are in green are likewise not required by CCPA, we believe that they are part of the best practices privacy program. Knowing where you are at the beginning helps you to be smarter about where you're going. As we said, instead of doing ad hoc one-off projects, trying to solve one thing at a time. Assessing where you are and determining where you need to be really makes a lot of sense. And I would actually argue that that training step be colored red. We've got it green, but I'd argue that it's red because without people are not going to understand how to comply with the law, and that would bring you out of compliance. So I actually would make that red. And then getting rid of your information is really just good practice from an information governance standpoint. And again, at the bottom, we've got privacy program organizational development. Again, if there's nobody to run it, if there's nobody to oversee it, then it makes compliance with that that much more difficult. So we would argue that all of these steps are great steps to have. The ones that we wanted to try and at least let you know what do you absolutely need to have if you're looking to get to compliance sooner than later with the California Consumer Privacy Act. And I guess speaking of information governance, because we were kind of talking about that on that last slide, there are a couple things that you really should consider when you're implementing your CCPA program. Although the California Consumer Privacy Act does not provide guidance on how long to keep personal information, guiding privacy principles really dictate that personal information should ordinarily be kept no longer than necessary for the purpose for which it was collected. Sometimes, however, that purpose could mean that you need to keep it longer than you would think. Understanding all of this will really be important as California Consumer Privacy Act and other privacy laws start to roll out. We did a webinar on the top 5 ways your outdated retention schedule could affect GDPR compliance. We think that there are some ways that updating your schedule will help you be more compliant with the law. You also want to look at your legal hold processes and whether or not they take personal information into account. This may be another process that your company goes through where personal information is involved, and including that in a personal data inventory is a good idea. So understanding how your legal hold plays into personal information, also a good thing to look at. Now, so I think over the past almost an hour now, we've spent some time talking about how to best succeed in developing an action plan. Mark, do you want to talk next kind of about some of the ways that these efforts can fail?
Yes, we've seen a lot of different privacy programs and information governance programs. And watching these, we've seen a number of trends. And we always think it's important to highlight these trends early in the process, so if we can anticipate them, we can avoid hitting these roadblocks and having our program either not get completed or not really get off the ground or not be compliant when it is actually initiated. The first one, and this one we think is particularly acute for CCPA, is what we call policy-itis. Sometimes there's a tendency to focus on the policy and updating the policy and creating the policy to the exclusion of actually executing the policy. We think this is particular for CCPA because, as we mentioned, the Attorney General will want to be updating this law. And so there's some that may say, well, I need the policy, I need the perfect policy. Compliance doesn't come from the policy. Compliance comes from actually executing the policy and demonstrating that you're following it. And so too much time spent on the policy, not on execution, puts you at risk. The second one is siloed approaches. One of the things you may have gleaned from watching this webinar is that it actually takes a lot of different individuals. It's the privacy, it's the legal, it's the compliant, it's the IT, it's the business units. It's good to have a individual may lead this effort, but it really does require a team to be able to execute this. And if one single department single-handedly tries to take over complying with this law, we don't think that's going to work. We don't think the siloed approach won't work very well and could run into problems. The next one is, theoretically, you don't need any of the technology processes that we talked about. You could do everything manually. We think, however, as we've seen with other privacy laws, we almost expect a cottage industry to develop in terms of personal information requests from California consumers. And so we think there's a significant risk that if organizations have everything as a purely manual process, trying to search for everything everywhere, that this will not scale and this will fail. And so organizations really need to think about how do they make a repeatable, consistent, automated, streamlined process, either for providing access or deletion requests out there, because those could pile up pretty quickly. And so, and again, it depends on how many California consumer employees you're dealing with, but we think that that's potentially a big issue. And then the final one is starting too late. At the recording of this webinar, we basically have around 16 months until this law needs to be implemented. It's not a lot of time. Other laws, we've had a lot more runway. And so we actually have clients today that have already started implementing this, and we think that's good. We think a lot of organizations should jump on this. I think if you wait too long, you wait till things really run the risk of running out of time and not being compliant by January 1st, 2020, which is the date that this law goes into effect. There are other pitfalls that organizations could run into. These are just some of the more common ones that we find, but we think it's very important to be able to anticipate that. So we're ready for questions. We've got to ask you to post some questions out there. We've got some questions already. While we're doing that, we talk a little bit about Contour. We're the largest provider of privacy, records information management, litigation readiness services. We're independent, we're cross-functional, we're flexible, we're experienced, deep expertise not only in GDPR, other types of privacy, as well as other types of information governance. We work with more than 30% of the Fortune 500, many small, medium-sized enterprises. We work on a global basis. Tremendous expertise in this area in terms of not only helping organizations develop policies, but more important, helping them execute those policies throughout the enterprise. We're independent, by the way. We don't sell any products or store any documents. Our clients like that because we can give them advice based on what they need, and we don't have a product agenda in our back pocket. We have a fairly robust set of California Consumer Privacy Act services, everything from assessments to inventories, organizational structure, helping understand policies and procedures, enhancements, taxonomy and file plan, training programs. We really have a full suite to help organizations very quickly, efficiently, and cost-effectively come up to speed on this law. So if you're thinking about that, be happy to more and talk to you about that. And then finally, this is a complex issue, and there's a lot of stakeholders involved. We do offer a complimentary two-hour on-site seminar implementing California data privacy. We actually get the right group of stakeholders together, and we can come on site, not a pitch for Contour, but really talk, and you've seen some of the content we could address, but as an on-site seminar for your team to say, hey, let's walk you through what organizations need to do to be able to comply with CCPA. So this is available on our website, so if you're interested in that. And then finally, a couple more things. We're just about to start on September 13th, and if you're watching a recorded version of this webinar after that date, these will all be recorded, but we have an introduction to information governance. We've built a 6-part course for the in-house practitioner, and we'll talk about a variety of subjects. It's really an introduction to information governance, what organizations need to do. We will be talking about privacy and data classification as part of that, but also other aspects of information governance. So something to look at out there. And then likewise, we have some events out there, one in Charlotte, one in Boston coming up. We're going to be talking about mobile and social media. We'll be touching on privacy. So go take a look at some of those events. Again, email us at info@contour.com. And so with that, we're ready to be able to answer some questions out there. And again, post your questions out there. Tom, you mentioned something about 50% of revenue coming from personal information. Can you expand on what is the definition? And I think the questioner is asking, what qualifies you to be mandated to follow this law?
Well, and I'm going to start out by saying that even though I am a lawyer, we're not practicing law for purposes of this webinar. So my disclaimer will be that I'm not going to give any legal advice. And 2, keep in mind that this law could change. So it'll be tempered by the fact that things may change. But of the 3 requirements to qualify as a business under California law, one of those requirements could be if 50% of your annual revenue comes from the sale of personal information. So if you're in the business selling personal information to individuals and 50% of your revenue comes from that, then that would qualify you as having to comply with California privacy. Now, it's only one of 3 requirements, so it may be that even if you don't sell personal information or that you don't, 50% of your revenue doesn't come from that, you may still qualify under the other 2, but that's what I generally understand that requirement to mean.
Greg, I got a question here for you. What are the best practices for removing specific data elements from backup files going back several years or months? That's a good question. If somebody says, what privacy information do you have on me? And maybe the organization has some old backup tapes. Does the organization have a responsibility, an obligation to go search for any privacy data it may have on old backup tapes?
Yeah, I'm afraid that the days of keeping backup tapes for long periods of time really have passed. Not just for privacy reasons, but for others as well. You can't get away any longer with saying, well, tapes are too hard to look at, so I'm not going to produce the information. The reality is in today's modern world, you really shouldn't be keeping backup tapes as long-term archives. You should have an archiving system, or you should be using legal hold to keep information on just specific individuals and specific cases, not keeping 10 years worth of data just in case, quote unquote. So the reality is we don't recommend anyone keep a backup tape more than 30 days, period. So from that perspective, yes, you will have to go back and look at the data elements in backup tapes, and what that means is restoring that tape onto a system, rebuilding the system to its original state, and then using some kind of search tool against it. So not a really good idea. So from a legacy data perspective, backup tapes may be the first thing you want to go after.
But I will say real quick, if I could add, the law actually around personal access, information access requests is very specific, that says that a disclosure shall only cover the 12-month period preceding the business's receipt of the request. So under the way that I interpret this now is that right now businesses are only required to disclose the last 12 months of information they may have on a consumer. So I think there's a lot more to see here, and I think there's going to be a lot more interpretation to be made of that, but that's another issue to take into account when figuring out what your backup tapes hold and how long they've been holding information.
Interesting. Well, it's interesting. Previously, from a compliance perspective, it seemed like organizations got in trouble for failing to have minimum record retention requirements. We're seeing the other side of the coin now, which is sometimes holding data, and organizations that applied with the European GDPR requirements realize this. Now it's becoming penal if you hold data too long. I mean, you have to have it the right time, but you can't hold it too long because that creates more of a risk or a compliance problem for organizations. Tom, got a question for you here. Are California employees to offer the same rights and benefits as a California consumer?
So yes, we talked about this at the outset. If you are a natural person residing in the state of California, that's how consumer is being defined. So you are, even if you're an employee of an organization, you are still a consumer for purposes of this act, and you would be covered. Your personal information would be covered the same as customers of the company.
So is this law just for businesses, but also are local governments also required here?
I don't believe that local governments are required because, again, there is a requirement that you be collecting personal data, that you may be making revenue off of it. My understanding is, and again, you may want to review the law and to check with your attorney, my understanding is that this may not apply to governmental entities.
Interesting how the state of California gave a special carve-out for itself and other governments. Interesting to, it's good for the gooses, not for the. Are sell and share the same thing?
Yes, sell and share are the same thing. They have made a very broad definition of making data available to other people, and you don't even have to make money off of it. If you share it, if you just give it to someone, then you are in effect, quote, selling the information. So yes, sell and share would be the same thing under the Act.
All right. With that, we are completely out of time. I want to thank both Tom Mighell and Greg Forrest from Contour for giving some excellent insight. Again, this webinar will be available for replay. And if you would interested either in our on-site seminar or you want some information about this and other topics on our website, all complimentary, please let us know. Or if you want to talk to us about helping you prepare for your California Consumer Privacy Act, please give us a call. And in the meantime, we wish you success as you comply with this program. Thank you very much.